Hello, I'm Angela Princewill, and on this quick video, I want to talk to you about the risks of drafting your separation agreement yourself and including child support provisions that are not actually the table amount. So I usually, well, not just me, the entire bar and judiciary refer to these separation agreements drafted by parties themselves as kitchen table agreements. And I have several, podcasts and blogs where I've talked about sort of the risks that come with that. But I just noticed I've come across this issue a couple of times, and I just thought I'll put out a video talking about child support and the risks to you when you draft your separation agreements yourself and you include provisions for child support that are not the table amount. So for those that are unaware, child support in Canada is paid based on the child support guidelines, also referred to as the tables. And what the table means is each province and territory has its own sort of amount that needs to be paid based on your income. So that's the child support table. It has every income amount and up until $150,000 and the amount of child support that's payable based on your income. I've noticed that, for people that do things like, cash jobs or, for whatever other reason have incomes that are underreported to CRA, I have seen that when they negotiate child support, that they often would base the child support on an amount that is higher than what's on the notice of assessment. So for most people that are employees, if they want to figure out what the child support amount is, they would look at, the table, right? So if your T4 or your notice of assessment says you made $50,000, you look at $50,000, the number of children, and it tells you exactly how much you need to pay. And it's usually risk-free, so long as you're paying the child support amount, it's, you guys use the correct number on the table, that's fine. But say, a person is making $50,000, that's what's reported to the CRA, whether legitimately or illegitimately, that's not, or illegally, I should say, that's not the concern with this video. The point of this video is there's times where there's a recognition that, the income for child support should be higher because the amount on the notice of assessment, either because the person is self-employed, as I said earlier, get some income in cash, things like that. And that's fine. So what happens with, people in those situations is sometimes they just pick an arbitrary amount of child support and say, well, I would pay $1,000. Usually, if you have a lawyer drafting that, we would either try to estimate the income and make sure that we match your child support with the estimated income so that it's easy to follow and avoid difficulty in the future. Or what we could also do is make it clear that, this is excess income is $50,000 and the parties recognize that that's not the appropriate amount on which child support should be set. And so they're going above the table, or even this would conversely apply if you're paying less than the table amount. But you need to make things clear. And I think it all comes down to clarity and drafting it properly so that when one party, because the two recent incidents I'm referring to have been, situations where a party isn't paying child support anymore. And it's now like, well, was he or she overpaying or were they underpaying? How did this amount come about? Is there any basis to make them pay that amount? None of that is articulated and nobody really, so it just creates problems, right? And it's almost like the parties have to start from scratch. And when you're talking about a separation that's happened years ago, it might be sometimes difficult to establish how the parties got there to that amount, at least, getting both sides on the same page and saying the same thing. So there are risks when, income is not clear. And that's why it's important to seek independent legal advice on your agreement so that we can help direct you and make sure that it's drafted in a way that if there's non-performance, it's easy to understand and enforce. And, and that a person picking up your agreement years later could look and understand, why is the support amount this way? Why is it being paid more? Why is more or less being paid? And how do we deal with any subsequent changes going forward? Where there maybe even include some mechanisms or formulas with which to determine income in the future, right? So there's people that have fluctuating incomes and things like that. Maybe we can provide, give you some guidelines to make sure that you address that going forward, and not just saying we just pick this amount, and when the person is no longer paying, it's like, well, what to do, right? They were already overpaying anyway, and it just almost seems like it was something that was done as a favor versus something that was a reasoned decision at the time. So it all comes down to clarity. It all comes down to proper drafting, and it all comes down to you understanding that there's risks when your agreements are improperly drafted or articulated. So do seek independent legal advice, even if you're drafting it yourself, just to make sure that it's clear and that we give you directions on how you can, clarify and correct and make sure that everything goes well. Okay. So this stuff is important. I know I've spent way more time than I wanted to on it, but it's important. It would save you a lot of headaches in the future. And it's just a few minutes to speak to a lawyer and get it right the first time. All the best. Take care. Bye-bye.